I study traffic law, and to my satisfaction, I have achieved an awareness of what's happening in relation to the license, using a car, so-called traffic tickets, traffic court, and it's not good. In fact, it's very bad. I wonder how many people on the call are aware that the word driving isn't defined by the legislature in any of the California codes. Now, I'm convinced that the legislature hasn't provided the definition. So how can people be so sure that's in fact what they're actually doing when they use a car to go somewhere?
Now, believe it or not, Rich is actually telling the truth here. Vehicle code does not include definition for the terms drive or while driving. And the case law for this, at least in California, is People v. Nelson, and the citation is up there. It's a 2012 case. And this is a case where a guy was stopped for using a cell phone, and he's arguing that he's not driving because he was stopped at a red light. It's got a huge discussion of the definition of driving. But here's the key part is over here in statutory interpretation. Quote, "We must give the words of a statute plain and common sense meaning unless the statute specifically defines a word to give them a special meaning. In other words, the legislature does not need to define driving because it's a plain and common sense word. Unless the legislature gave it a different meaning than the plain and common sense meaning, the normal dictionary definition is what applies." And this is also made clear in the final paragraphs of the decision. Quote, "Giving its words a plain and common sense meaning, driving includes stopping." And it gives a few examples of how the word is used. Any mom or dad driving kids to school can expect to stop while parents in car are a shopper driving to a store, a couple going for a Sunday drive. Drivers may and sometimes must stop, but they do so while driving. So ultimately, his argument that the word is not defined in the statute is ultimately meaningless because it does not need to be defined. And any confusion about the word is clarified in the case law.
Driving's a job. I don't drive anywhere. I didn't drive over to the grocery store yesterday. I used my truck to get there, but I didn't drive.
Well, no. If you used your car to get to the store, you drove there.
Once again, the prosecutor ignored People versus Sava. People versus Sava. S-A-V as in Victor A. People versus Sava. For all you folks in California who may not have this case, it's gold. It's the only case in California history that contains these four words. Infractions are not crimes. And then they ice the cake with this. The legislature never intended infractions to be crimes. That decision was rendered in 1987 here in California. It's never gone up to the Supreme Court of California. It's never gone to the Supreme Court of the United States. It stopped at the Court of Appeals. Guess what? It's good law.
Well, guess what, Rich? It's actually not good law. In 2015, a guy tried the Sava argument and lost. And thanks to that case, we have a very lengthy discussion of why infractions actually are crimes and why the Sava case is bad law. Quote, Sava is the lone case Glassner cites regarding the nature of infractions. The case on which Sava relies for its statement regarding the criminality of infractions, People v. Battle, was later rejected by another case, People v. Hamilton. So, in other words, the case that Sava cites to claim that infractions are not crimes was overturned in 1986. And we can read in the Hamilton case, quote, Section 16 of the Penal Code declares that crimes and public offenses include not only felonies and misdemeanors, but also infractions. Going back to the Glassner case, we can read, quote, in California, however, traffic infractions have not been decriminalized. It has long been recognized that traffic violations are classified as criminal offenses, and it cites the Penal Code, quote, shall be imposed on every conviction for a criminal offense, including a traffic offense. Thus, speeding infractions in California are crimes. Indeed, Section 16 of the Penal Code defines crimes and public offenses as encompassing felonies, misdemeanors, and infractions. Further, California courts routinely refer to infractions as crimes, and referring specifically to Sava, quote, that a court stated the contrary in 1987, something Glassner notes, does not change the state of the law or the meaning of the word infraction in California.
Because ain't nobody using Sava. I don't understand why.